Hello, everyone, and welcome to another Q&A with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office, and please join me in welcoming attorney Ishan Anand from our Herndon, Virginia office. Hi there, Ishan, and welcome.
Hi, thank you.
Thank you so much for being here. For today's topic, we're going to be answering all your pressing questions on immigration. Just a quick disclaimer before we get started. This conversation is for informational purposes only. It does not create an attorney-client relationship. So if you have questions, please comment them below or email us anytime at info@chug.com. Let's get right into it, Ishan. Can I use my EAD or AP and still maintain my H-1B or L-1 status?
Well, we cannot use both. You can use either your EAD. I'm assuming you're talking about the adjustment pending EAD and advance parole. So once you use that, your H1 or L1 status goes to sleep. I'm not saying you will go out of status or your H and L will die. It will just go to sleep. You can reactivate it. There are ways to reactivate. Suppose you have an urgent need to travel and you use your advance parole. What you can do if you eventually want to reactivate your H or L, you can simply travel and do the suppose go to Mexico and get the automatic revalidation, then come back with H or L, you will reactivate your H or L status. But you cannot have both. You need
Got
to
it. That's
choose. Yeah.
that's really helpful to know. Anything else you want to add on that, or sorry, I interrupted
You,
you.
you, you can also no you can also change you can also suppose you file an extension and go for consular processing, come back, you can still activate your H and L. So you will either be on adjustments pending status or your H or L.
Got it. Thanks so much for explaining that to us. So let's say, for example, my OPT expires on April 30th. Do I need to change my status to B2 if my employer is filing for my H1, which starts on October 1st, for example?
Yeah, depends if you are picked up in the lottery and you know that the employer is filing for your H1. The only caveat here is that your H1B petition, the USCIS needs to receive it before your status expires. In this case, I think it's April 30th, right? So yeah, so before April 30th, the USCIS needs to receive your H1B petition. Then you will be fine until September 30th if you are joining the employer on October 1. You'll be fine. You don't have to file extension or B2.
Wonderful. Great to know. Thanks for sharing that with us. So, question on the H-1B, is the H-1B visa purely lottery based, or are there also options without the lottery? Is there anything we can do to get around this? Do you have any insight on that?
Sure. Generally, it's lottery based, and lotteries are basically there are different caps. One is bachelor's cap, one is master's cap, and then there is one more thing called cap exempt. So for the masters, you have more visas available, so that's a better option. And then there's a cap exempt. How you can be cap exempt is if your employer is a non-profit research organization. There are different employers. If your employer is in research, it's a non-profit, then you can be cap exempt. One more way to avoid the lottery is suppose your employer is not cap exempt, but the end client is, meaning your employer is sending you to work at a nonprofit research organization, which in turn is cap exempt. You will be cap exempt. We have done many cases in where the employer itself is not cap exempt employer, but the beneficiary goes to work and the end client where the beneficiary is stationed is a cap exempt employer. So then you don't have to go through the lottery.
Wow, that's really good to know. So some businesses are cap exempt, and there are also opportunities to be cap exempt if the business isn't, but the end client is. That's great to know. Thanks for sharing that with us.
One
So
more thing I want to add
please.
here is you can also do concurrent filing, meaning one of your employers is cap exempt. You can have you can file concurrently. Suppose your cap exempt employer hires you for maybe 20 hours a week. So you can then go and join another employer, which is not a cap exempt, but gives you the benefit uh, of joining them and still be considered cap exempt. You don't have to go through lottery in that case.
Wow, so it sounds like there are quite a few opportunities here. So if you are watching this and you have questions on this, please comment them below or email us. We'd be happy to help you out. So Ishan, what are the minimum qualifying criteria for H-1B and what constitutes a specialty occupation? Can you share that with us?
Yeah, so specialty occupation is a term of art. USCIS uses a lot in its RFEs and all. Um, so to cut short, the minimum qualifying criteria is the job that requires a minimum of a bachelor's degree. That qualifies you for H-1B. So basically, an occupation which requires a theoretical and practical application of highly specialized knowledge, meaning something that an occupation which requires a minimum competence of a bachelor's degree is the qualifying criteria for H-1B. And how you can show that a job requires a bachelor's degree, there are different ways. Say the industry standard is such that for this particular job, the industry-wide standard is bachelor's degree. Or you may say that the employer requires, historically, the employer required bachelor's degree for this particular kind of job. Or the skill required for this kind of job is so technical that you need at least a bachelor's degree to perform the job competently.
Understood. So the minimum qualifying criteria is generally a bachelor's degree.
That is correct.
Got it. Thanks for sharing that with us. So how does one decide between selecting an H-1B visa or an L-1 visa? What's the difference and what do we need to know about these two visas?
So there are, I think there are more than 20 non-immigrant visas that's available for everyone. And when I say non-immigrant visas, meaning um to come here and work here temporarily and having an intentions to go back. However, the two mostly used, like widely used visas are H-1Bs and L-1s. And how can we choose between the two depends on the basically criteria. If the company is a multinational and the beneficiary has worked overseas for one complete year within the last 3 years of transfer, then the person qualifies for L. And that the work that the beneficiary has done outside the country needs to be either managerial, executive, or in specialized knowledge. Basically, what is specialized knowledge is again a term of art, meaning in a capacity where this person is vital to the operations of the company. Like it gives this particular employee gives a cutting edge to the company, or handles an operation which requires um, years of experience, which you cannot teach other people easily or in a year or two. That kind of person. So if you have that kind of person, either managerial or executive or specialized knowledge, working outside the country within your corporate structure, meaning where you have management control, then you can transfer that employee to domestic company that's called L1. But if you do not have it, if it's not a multinational, if you have only one office here in the US and you want to hire somebody from outside, yes, you the option is H1B. There are different ways. One thing also for H1B, there's a minimum qualifying criteria that the job requires minimum of bachelor's degree. On the other hand, for L1s, that is not the required criteria. So L1B employee can be somebody without even a bachelor's. However, the person has to manage professionals. So it's a tricky combination, but all in all, there are different criterias, different requirements. So we need to be very careful to choose between H or L. Not every person or situation um, gives you the benefit of both, basically.
Understood. I appreciate you explaining the difference between those two. There are so many visas, like you said. So if you are watching this and have questions on the other visas, please reach out to us. We're happy to share with you all of the options that are available for this. So Ishan, are we able to change our employer after the I-140 is approved?
Okay, so it's a heavy question. There's a lot in this question. Let's see. Let's dissect in four different stages. Stage number one is when you have a perm approved and you file the I-140. So I-140 filed day one. What will happen? What benefit you will get? So what will happen if you file the I-140 and the I-140 is approvable when filed, gives you the benefit that you can use that perm indefinitely. Even if your I-140 is denied eventually, you can use the same perm n number of times. There is no limitation as long as the I-140 was approvable when filed. Can be denied for many reasons. We will not go into the details of denial. Stage two is I-140 was filed and approved day one. So suppose the I-140 is approved today, then what will happen? What will happen is the beneficiary will retain the priority date. Now, nobody will can take away the priority date, meaning that there's a backlog in the employment-based categories. So the earlier, the better. So it's very crucial that you lock your priority date, and then if the I-140 is approved today, you will lock in the priority date, not today, basically the when the perm was filed. So you will get the priority date of the perm. Now, many people confuse this with portability. Now, changing employer has everything to do with portability. So as of today, when you have the I-140 approved, there is no portability. Portability happens later. Now, suppose the I-140 is approved, stage 3, and 180 days have passed with the I-140 only. We do not have adjustment of status right now. We do not have 485 pending. So what are the benefits of this situation? This gives you basically the benefit to extend your H1 or H4 status indefinitely. So generally, you have 6 years of H1 status, but if you have your I-140 approval and then 6 months have passed, 180 days have passed, so you can extend it automatically. You can basically extend it indefinitely. You don't have to go back to your country. One thing very important to note here is we still do not have portability here. So you cannot, basically you can switch job, but then the employer has to file a new perm if you change the job. One important aspect here is I have heard people saying that if you can switch jobs if your job is in the same or similar profession. Well, that is partially true. Not in this case. In this case, even if you have I-140 approved as from in IT profession, some other employer can file I-140 as a janitor for you, and even then you will retain the priority date. So there is no uh, requirement for the employer to be in the same or similar profession here. Even then you will get the priority date. Now stage number 4 is crucial, where you file your 485. Now stage number 4 is when you file your 485 and file supplement J, the employer is confirming the job offer, saying that yes, I will hire this guy in the future. Now what will happen? Now you can change employer after 180 days have passed. Suppose the 485 is filed today, supplement J is filed today, job is confirmed, and after 180 days you find another employer. Do you need to file a new PERM? No, you don't have to. Can you port? Yes. Caveat, your employment needs to be in the same or similar profession. Only in at this step, the employment needs to be in the same or similar profession. Before this, well, when you are not porting, you can file your I-140 in any profession whatsoever. All you can have is just your priority date locked in. So, conclusion, the short answer is you don't have to. I have seen employers or beneficiary, employer X is filing the PERM green card, and beneficiary never set foot on the premises of that employer, ends up joining some other employer, still be fine.
Got it. So you're saying we don't need a new perm every time we change our employer if it's in the same industry?
Well, no, if you, it's different. If you go, I don't know if you will go. So there are different stages. So it depends. If you are porting or if you are not porting. If you're porting, then it has to be in the same industry, similar profession. But porting happens later down the line. It happens after the 485 is filed. Some people think that porting can also happen when the I-140 is approved for 180 days. Well, if the I-140 is approved for more than 180 days, you can join any employer, you can change your profession, you can do whatever you want, because right now you are not porting. You are simply using your priority date and nothing else.
Understood. Got it. Thank you so much for sharing all of that with us, Ishan. I do want to ask you about the EB1C visa, but before I get into that, we do have a live question. Somebody is saying they got a green card via EB1B in December of 2022, and they want to know if there are any restrictions in changing their job.
Okay, so when you get a green card, if it's employer sponsored, okay, you're required to stay with that employer for at least 6 months, because you and the employer, both of you are saying that it's a permanent job, and we have intentions to stay together. Well, permanent job doesn't mean that you will die with the employer. So you can switch jobs, you don't have to stay, um, but at least 6 months. Now, EB1B is for researchers and professors. Uh, Basically, it's not sponsored. It's just they give you an offer letter. They say that we will hire you if you get a green card. Okay, they don't go through the entire process of recruitment and all that stuff. So I would say if you have a green card, stay with them for some time, and if you find another job, you are allowed to move on.
Wonderful. Thank you for sharing that information with us. Now into the EB1C. Is the EB1C only available for workers who are in an L1A status?
L1A. Okay. So there's a notion that to qualify as an EB1C, which is managers or executives of multinational, which is a green card, you need to be on L1A status, which is also a non-immigrant visa for similar category, managers and executive for multinationals. There's a notion that you have to be, but it's not required. You can be here in the US on some other status, but if you have a qualifying job that suppose you have worked in past three for one complete year in past 3 years outside the country with the qualifying entity, meaning related entity where there's a control, management control we call it, and of this multinational, and you entered this country and work with any of the concerns within the organizational structure, you still will be qualified. You don't have to have L. You can have H, you can have L, but if you meet all the qualifying criteria of EB1C, you are eligible.
Got it. So do I qualify as a manager for EB1C classification?
Manager or executive. So you have to be very, very specific with your, basically, it's not the job title, it's the job duties. So if your job duties are managerial, that you manage the team, you supervise them, you have the authority to hire and fire, these are managerial duties. So if you are a manager, you have to be very specific what your job duties are. And if you have worked uh, one complete year outside the US for affiliate, branch, subsidiary, holding company of a US entity, then you can be transferred. If US company gives you a managerial or executive job, then you can file for EB1C. It does not matter if you entered the country on L1, H1, or some other visa. It does not matter.
Great, thank you for sharing that with us. So can we talk a little bit about the difference between the L1A and L1B visas? How does this affect the kind of employees a company can bring to the United States?
As we discussed, L1A is for managers and executive. L1B, on the other hand, is for specialized knowledge worker.
Mm.
Now, the difference is the specialized knowledge employee is someone who gets there or who knows integral function of your company, which uh, gives the company a cutting edge or the branding or something is that differentiates this person and this person's value in the firm, so which cannot also be taught easily. Like I cannot, so suppose if this person, I can create people like this person easily, then this person is not a specialized knowledge person. This person needs to know something which comes by years of experience and gives cutting edge to the company and cannot be taught easily. These three, four things that this person has, that's a specialized knowledge person. So if you do, there's the thing is, if you transfer somebody as a specialized knowledge worker to the US, the you will get 5 years, 3 years, and then 2 years of extension. If you do the L1A, which is a managerial or executive transfer, you get 7 years, 3 plus 2 plus 2. So, which is very important. Also, you can, uh, if you try, if the person, suppose the L1B, meaning this person was a specialized knowledge person, right? So, if this person was not a manager or an executive, you will not be able to file the EB1C, because eventually for the beneficiaries and for companies, the long-term uh, um, route is to file a green card for these guys. So in this case, if the person did not meet the criteria of managerial experience outside the country and you brought this person as a specialized knowledge worker without managerial experience, then there will be difficulty in filing for a green card.
Understood. I appreciate you sharing the differences between those two and what that looks like. So let's get into approval rates. What are the chances of getting an H-1B, L-1, or PERM application approved nowadays? And is there anything we can do to improve our chances of getting approved?
Well, approval rates, I I don't know. I cannot comment on approval rates. As far as I know, if you file petition properly and if you know what you are doing, then the approval rates are pretty high. Meaning H1s, L1s approval rates are pretty high if you know what you're doing. So, I'm sorry. What you are doing, meaning you cannot file an L1A managerial transfer by having job duties described, and in the job duties you are mentioning all the jobs that relates to an executive employee. You have to be very careful. If you do that, if you do not bifurcate what's executive duties and what are the managerial duties, you will have a denial. You have to tell USCIS if it's a managerial transfer or an executive transfer. I have seen this in many cases where you have a mix of both duties, managerial duties and executive duties, and you tell USCIS that it's a managerial transfer, and USCIS comes back saying, just tell us if it's a managerial transfer or you, because you could not differentiate or define the exact duties of this guy, so they deny the petitions. Same thing if you file an H1B and USCIS believes that the job is not something as a specialty occupation, meaning requires minimum of a bachelor's degree, there will be a denial. And if we go with the green card process, if the employer who is filing your case has no ability to pay, meaning there are losses and the company is under bankruptcy, cannot pay your salaries, there will be a denial. So but if everything goes right and then you prepare your case properly, you know what you're doing, I think the approval rates are pretty high.
Understood. Thank you so much for sharing that with us. And like you mentioned, the documents and everything that you're providing is so important. So if you are watching this and have questions, make sure you're working with your trusted attorney. Please reach out to us if you have questions. We're happy to help you out. Make sure you have everything necessary to have the highest chance of approval. We are running out of time, so just one more quick question from the audience, Ishan. Somebody is saying they got an EB2 GC EAD, but they're still waiting for AOS as priority date is still not current. Can they change to a new employer based on EAD and not go through the H-1B transfer?
Well, I'm assuming you have an EAD, meaning you have adjustment pending. And as we discussed, if you have adjustment pending for more than 180 days, you can switch employers. You are under portability guidelines, and make sure that when you port, you stay under the same or similar occupation. Don't change your occupation.
Got it. Thank you so much for sharing that with us, Ishan. I hope that was helpful. If you guys have more questions, please email us anytime at info@truth.com. We're happy to help you out. We'll connect you with Ishan. He's our immigration expert. So that is all we have time for today. That does bring us to the end of our conversation. Thank you so much, Ishan, for sharing your insights and taking the time. Thank you, everyone, for joining us today. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, please send us an email at info@truth.com. Let us know what topic you want to see next, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you so much for joining us.